I'm arguing, I will say we. I may represent a corporate client. I may represent an individual. I don't say we because I'm trying to mouth that. I say we because by the time I have stepped up to argue it, I've adopted it. I believe it. So I say, we did this, or we did that. Or I can say my client. But the point is that I'm completely aligned with my view that I'm arguing. If you can't be completely persuaded yourself, you're not going to persuade a judge. They recognize the phony, and they recognize an argument that you don't have your heart in. When a client comes to us with a litigation problem, something is hurting very, very badly. It might be that someone has sued them for a large amount of money. It might be that they've been damaged or injured and need to sue someone for a substantial amount of money, because we do civil litigation. But when they come to us, something is badly broken. So it's not an issue of us having to listen to the client or the client calling the shots as to what it wants. We're like a surgeon. So in our type of litigation, when somebody comes to us, they need the surgeon to go in and do what has to be done. They can't tell us what that is because they don't know. They can tell us what hurts, they can tell us what the problem is, but it's our role to analyze what the situation is, decide what the solution to it is, and then develop the game plan that leads to that solution. In our case, often a trial or a settlement. But when they're coming to us in that context, they're saying things like, my people have left me, or what do I do? This is terrible, this is horrible, how can they do this? It's those kind of things that we're seeing. This isn't like sitting down with a corporate client who says, we need to draft a new prospectus. Would you take a first crack at it? Or we need a contract to buy such and such. These are people with very serious problems on one side or the other, plaintiff side or defense side. So when they come to us, they're coming to real specialists who are trial specialists to analyze their problem and help them find their way out of the woods. I don't claim to be a psychologist, and so I don't deal directly with their stress. I try to ask them to relax, leave the legal issues to us, answer our questions, not to worry about why we want this particular information or that particular information. To some extent, I'll let them ramble on and tell us about their problem or their issues, but generally there are emotional things in there. They aren't focused on what the real issue is. So I don't get a lot out of that. I may pick up a little something here and there to follow up with. But essentially, in a litigation matter or a trial matter, once I hear the basic scenario, then I know the questions that I need to ask them, and that's the material that we're really going to use to analyze their case. I had a friend who was a judge at a dog show. He judged German Shepherd dogs. And he said when he was judging a dog, he'd look at a German Shepherd dog, and in his mind he would imagine what a perfect German Shepherd looked like. And then he said it was easy. He'd just compare the head on this one to the head on the perfect one, the stance of the back on this one to the stance of the back on the perfect one. So he had this gold standard in his mind, and he was always comparing what he was looking at to that, and he'd make his judgments and give his points on that basis. Facts are the same way. Facts are not just going to be random. Facts are not going to be crazy. When you know some facts, like an archaeologist, you should be able to project most of the rest of the animal. When you have one bone, it has to fit in a particular way with the other bones and fit together. That's how they can reconstruct a dinosaur or something from a toenail that they find, practically. Law is the same way. So when I'm looking at facts in discovery, I have in mind what must have happened here given what we know. Given that we see this, what can we project was really the rest of the picture? And then I push hard to get to those facts. Beginning of a case, when you learn the basic facts from the client, you want to know what it is that's the problem, how did it develop, when did it develop, what they have done about it so far. Once you do that and you have the basic operative congeries of fact that you're going to be dealing with, then you have to hold those facts up against the legal skeleton of the law and see where they fit against what the law allows. So you may have a client come to you with a serious problem, but the law doesn't have a remedy for it. So, for example, we recently had a client whose father cut him out of his will, and there was no real remedy. The father had the absolute right to cut him out of the will. You see that often with older people who meet a younger spouse, for example, who have adult children, and they may be very unhappy about the situation with their parents. They may think the parent is doing something very foolish, but there's no legal remedy, so it doesn't fit against the law. In another case, there may actually be some senility or some undue influence, using the example that I just gave, where a parent is doing something where a child should step in. So once you've got the facts, you hold it up against the law to see how the law applies to those facts. You may need to assign out legal research on specific things within your own office, and eventually you develop a game plan. That is to say, how am I going to develop the facts here? How am I going to take the legal steps necessary? Do I file a complaint? Do I file a motion? Is this a case already in process? Am I going to file an answer? How do I prepare the witnesses for trial? So the game plan is going to cover the integration of the facts and the law to prepare the client and the case to put it in the best possible position for the trial. Whether plaintiff side or defense side, it's going to be the same general approach to the analysis, and then it's just a matter of execution and carrying out, taking the depositions, arguing the motions, standing up and talking to the judge or jury and arguing the case. You've got to be organized. You've got to have the control of your material. You have to present 2 or 3 takeaway points. You show me a lawyer who tells you that, oh, this is too complicated. I can't explain this. It'll take too long. If that's the case, the lawyer doesn't understand the case. Every case comes down to 2 or 3 takeaway points with a jury. Has to. You get up and argue to a judge on a motion. You better have 2 or 3 takeaway points, because if you got any more, you've lost the judge. So find out where the heart of your case is. Don't worry about the feet and the hands and the periphery. Get right to the core. Don't be focused on the capillaries. Focus right on the core. What is your case about? And show the judge why that compels a particular result. Or what is your motion about? What is this motion about, rather than your case if you're arguing a motion? The motion also has a core element. So go for the arteries, not for the capillaries, every single time.